Hello, my name is Trent Norvell. I represent a firm of Norvell, Rowland, Sau, and Orozco, and today we will be doing a presentation of a in-depth analysis of a commercial real estate license agreement. Now, before I go into the actual contract, I'm going to stipulate what exactly are the elements of a lease contract. First, we have the consideration can be financial or an exchange of services. A lease is a bilateral contract. The government, through contracting officer, has some unilateral rights to it as well. The tenant and the landlord must be of age, sanity, and sobriety when signing said contract. The contract is, for legal purposes, written under the federal government, and the lease contract may not be open-ended, and it has to have a start and end date. And finally, a lease is a binding agreement that is enforceable by United States law. Now, this contract is between ABC Properties and Zion's Company LLC. ABC Properties is the landlord, and Zion Company LLC is the tenant, proposed tenant and proposed landlord, excuse me. And what we are going to do is we are going to provide a in-depth analysis where we will define the protections and responsibilities of each side of the contract with a hopefully unbiased opinion and not to be inclined towards either of the parties. This contract has certain protections and responsibilities between the parties. Both parties get protections and responsibilities. They both have to share the weight. With the protection side of the contract, they both have to follow Section 28, which states that both tenants and landlords must obey all laws, orders, and ordinances and other public requirements when they are in use of the licensed and leased property. If they fail to do so, they have the right to null the contract. Another protection that both parties have is attorney fees. In case of a lawsuit for recovery of premise, any act which could arise out of possession of the premise by either party, the prevailing party will be reliable for all costs in connection with that action. That includes the attorney fees that get stacked on top of said protection. The responsibilities for each parties, the landlord and tenant, they both have responsibilities of the rental price, security deposits, fees, which are part of security deposits and rental price as well. They both have responsibilities for repair / maintenance policies, and the terms of the lease themselves are both of their responsibilities as well. And next, we will be going into some of the key points of the actual contract itself and point out the important parts of the contract that we should focus on and make sure everything runs smoothly. The first section that I want to look at and present to you is the rental section, section 2 of the lease agreement. The rental section states that the tenant shall pay the landlord during the first 5 years of the lease term to the sum of $288,000. The term of the lease begins January 1st, 2020 and ends December 31st, 2030, making the contract valid for 10 plus years. The lease will be payable in installments of $4,800 per month for the duration of 60 months in the lease, where each payment will be made on the 25th day of each calendar month preceding the first month due during the lease term of the landlord. It also states that the tenant shall pay the landlord a security deposit to the amount of $2,400, where the tenant agrees to pay the landlord the first and last month's rent and deposit $12,000 at the signing of the lease. Another section I want to go over is the fifth section, which is the repairs section. We want to clarify that the property will be given to the tenant in the current condition that it is. Any repairs towards flooring, walls, ceilings, and other damages, damaged or worn out parts of the premises will all be at the expense of the tenant and not the landlord themselves. If the tenant wants to make some alterations or improvements to the property themselves, they have to do it with the landlord's consent. The tenant may remodel, redecorate, and make improvements to all or any part of the premises at the tenant's own expense. The tenant may place and install personal property, trade fixtures, equipment, and any other temporary installations to their property. The tenant may also remove said alterations and improvements on the property, provided that if there aren't any damages, they will be repaired at the expense of the tenant and not the landlord, as stated before. Another important part to the lease agreement is the utility section, or the ninth section, which we interpreted that the tenant is responsible for paying for all utilities, which includes gas, electricity, water, sewer, telephone, and any other services like internet or cable during the term of the lease, which they are living there. If for any reason the utilities aren't paid by the tenant, the landlord will pay for them out of pocket and then invoice them to the tenant, whether that be the full payment of the utilities, or if the tenant cannot fully pay for their own, the landlord will pay for the remaining amount due. Another big section is the landlord insurance section, or Section 8, which states any damages to the building caused by fire or casualty resulting from the acts of negligence by the tenant or any of the tenant's agents, employees, or invitees, rent will not be halted while under repair, and the tenant is responsible for any cost of repair not covered by insurance. The insurance company must be issued and binded to the approval of the landlord, such insurance to afford a minimum protection of $1 million combined single limit coverage of bodily injury, property damage, or any combination of the pair. The landlord will also be listed as an additional insured on tenants' policies. That brings us to the damages portion of the contract, where the lease states that if there is damage done by fire, casualty, or structural defects that are not caused by the tenant, then they have the right within 90 days to terminate the lease. Now, if there's any minor damage to the lease premises that wasn't the tenant's fault, it is the landlord who must repair the damages at their own cost. If the landlord is repairing any damages and is delayed due to strikes, governmental restrictions, or inability to retain materials needed, labor, or any other matters that they're not in control, they will not be held liable. If the tenant makes a default and continues through 15 days, the landlord will give a written notice. If the default continues through 30 days, the landlord has the right to terminate and end the lease since there was a notice and rent was still not paid for. After the lease is terminated and the tenant does not surrender the leased premise, the landlord has the right to enter the premises and ask the tenant about default, as well as take the case to court. The tenant must obey the landlord's quiet rules, which are to be quiet, peaceable, and undisturbing during the term of the lease, the 10-year term. Section number 30, the option to purchase, basically says the option to purchase section focuses on whether the tenant wants to purchase the property or not. If the tenant wants to purchase the property, they have the exclusive right to purchase said property during the first 5-year term of the lease agreement. The tenant must notify the landlord 30 days before the expiration of the 5-year term lease. This lease, this final agreement, Section 31, the agreement terminates and supersedes all prior understandings and or agreements on the subject matter of the lease, any leases before it. The agreement may be modified only by further writing, which is duly executed by both the landlord and the tenant. And finally, Section 32 of the lease agreement, the governing law, states that this agreement shall be governed, constructed, and interpreted through and under the laws of this state of California, and witness whereof the parties have executed this lease as the day and year written, with 2 witnesses, one from the landlord side and one from the tenant side. I hope this in-depth analysis helped interpreting the commercial lease agreement between the 2 parties, and have a good day.